Hello. Hello friends, welcome to our show Dr. G.K. Goswami IPS, and today in this 26th series we are going to discuss with you judicial review. If you remember, we have discussed about constitutionalism, and constitutionalism is basically the spirit of the political power, how one wants to implement the basis or the basic precepts of constitution. So you can say the constitutionalism is constitution in action. In constitutionalism, we have discussed that how judicial review is a very significant attribute of constitutionalism. Why it is? Because the political power or the legislative power of the government, if they are uncontrolled, then they may dilute or divulge the basic structure of the Constitution. So we will be looking at various aspects of judicial review, what kind of judicial review are available globally, and we will be discussing the practices in India, United Kingdom, United States, Germany, France, and so on and so forth. So it will be a kind of global perspective. Today we are going to discuss about judicial review. So let's start, friends. Judicial review, a global overview. So what is judicial review? Judicial review, you might be knowing that judicial and review, these are the two terms. So judicial means that courts are involved for the purpose of review of what? Review of the actions of the legislature as well as the executive, because these are the three organs of the government. One is the parliament, who actually made the law or amend the law. Then executive, those who implement the law, and of course the judiciary, which adjudicate in the disputes, and they are the custodian of the supreme law of the land. So power of higher courts to examine. Higher courts means the constitutional court, like in India we have federal Supreme Court and the state high courts. Constitutionality or legality of legislative enactment. That means the higher judiciary has power to examine constitutionality or legality of legislative enactments. If there is any new law is being formed, whether it is within the parameter of the constitution or not. Then executive orders. There are several executive orders, whether they are in the line of the law or sometimes they are within the perimeter of constitution. Then administrative action. Administrative action are also the part of executive organ. Then declaring them invalid if they conflict with constitution or fundamental legal principle. So this is quite interesting. If you remember, after Maneka Gandhi case, we will be discussing that how A.K. Gopalan to Maneka Gandhi case in 1978, there is a voyage from procedure established by law to due process of law. So core judicial review is the core attribute for constitutionalism, so that it secures supremacy of rule of law. So this is very, very important part. So today what we are discussing, it is judicial review, which is integral part of constitutionalism, which is a sense how the constitution is in operation, and judicial review is a very, very sacrosanct power attached with the supreme judiciary in order to protect the constitution or the supreme law of the land. Now, there are different types of judicial review. There may be various classifications. The first classification may be a priori that is abstract. At what stage you are doing it? If you are doing before implementation of the law or before making of the law, or when the law is in the making process, then if you have the judicial review power, then it is called a priori. And it is generally in France, Germany, or you can say in those jurisdictions where it is they are generally where the supreme law is Constitution. And a posteriori, that is concrete, once law is in force, then only the judges has power to review. So a priori means before law get into final shape, that is in France, Germany and all. And then another is a posteriori, that means once the law is being made, then the court has power for review. The another one is very important. Friends, I want to tell you that laws in general are of two types. You can classify. One is substantive law, another is procedural law. Substantive law, like in India, we have earlier our Indian Penal Code, now we have Bharatiya Nyaya Sanhita or POCSO Act or various other laws where the ingredient of crime or about the law is being defined, and then there may be some punishment, compensation or whatsoever there. That is called substantive law. On the other hand, we have procedural law. Generally, criminal procedure codes or evidence act. They are type of procedural laws. So, if you see in America, they have due process of law. Due process means that in judicial review, the court look into both substance and procedure. But in India, if we see, we have procedure established by law as mentioned in Article 21 of Indian Constitution, which says that life and liberty of a person cannot be taken away without observing procedure established by law. We will see in the next slide. So, these are the two variants. One is due process of law and another is procedure established by law. So, I have written that procedure, then substantive and administrative actions ensuring legality of executive orders. So, these are the two variants. So, let us see about Indian scenario. In India, the power of judicial review actually emanates from Article 13, which says that those laws in India which are inconsistent with or in derogation of the fundamental rights, they will be judicially reviewed. So, Article 13 actually gives the power or provide the power to the superior judiciary for judicial review. And what type of judicial review we have in our Constitution? You can visit Article 21 where it is written that no person shall be deprived of his life or personal liberty except according to procedure established by law. So, this is in 21. So, you read 13 read with 21, then you will understand that where is the power of judicial review, that is in Article 13. What type of judicial review we have in India? It is in Article 21. However, Article 32 for Supreme Court and Article 226 for different high courts in India, they also provide writ jurisdiction, and under that the courts have power for judicial review. Another important point in India, one must know that judicial review power only Constitutional Court have. Constitutional Court means the Honorable Supreme Court of India and different high courts of different states. All matters for protecting both constitutional right and legal right. You might be knowing that Article 32, you can bring writ in the Supreme Court only for violation of fundamental rights. But under Article 226 in the respective High Court, one can bring or one can file writ for violation of fundamental right as well as legal rights. So, in this respect, Article 226 has wider scope compared to Article 32 for Supreme Court. So as I mentioned, Article 13 read with 21, then Article 32 read jurisdiction, and all these things putting together, we have procedure established by law in India in literal interpretation. But how it changed with time, we will see the different judgments. And the first judgment, it was decided by Honorable Supreme Court just after we adopted our constitution on 26th of 1950. Just after that, A.K. Gopalan versus State of Kerala. It's a very celebrated case, and those candidates who are appearing different competitive exams or maybe graduation, post-graduation, I think for everybody this case is very, very sacrosanct to know about it. So what are the facts? There was a communist leader, A.K. Gopalan, very prominent and stalwart, a very senior aged parliamentarian. He was supposed to stage a dharna next day, and under the preventive arrest, he was arrested in a day or a night before when he was supposed to stage dharna. Under the Prevention Detention Act 1950, it was claimed that procedure was observed. So he went to writ jurisdiction in the court, and the government took a stand that we have adopted due procedure. So court take a decision in majority. This case was actually 4-1. The legal issues were procedure established by law include due process or not, whether right under Article 19 and 21 are interconnected or not. These were the two questions. So majority view was they prefer literal interpretation. You might be knowing that there are three types of law of interpretation. One is literal, another is golden rule, and third is mischievous rule, right? So they took literal interpretation of Article 21, and whatever is written, they just took away, they just observed it, and they said that it is written procedure established by law. So we will not see the substance, whether that preventive detention law per se is justified or not. So we will not go by that because it is the subject matter of the legislature. We will see the procedure, and since procedure has been properly observed by the executive before arresting him, that is why there is no violation of his right. That is, and the writ was quashed. And it was told that fundamental rights are distinct silos, they operate separately. So the second question was responded negatively. They said that Article 19 and 21 had no interconnect. They operate in silos, right? They are separate. So judicial review means competent legislature plus procedure, proper procedure. So they are not going to see the quality of legislature. That was the interpretation. However, there was a decent observation by Justice Fazal Ali. That is very, very important, which actually was accepted in Maneka Gandhi in 1978. So you just imagine that in A.K. Gopalan, at that time our constitution was just neonatal, just born. But in Maneka Gandhi, it was 28-year-old, well experienced. The muscle power was strong, and more so, the country has faced emergency also in Maneka Gandhi. So the scenario was different. The ecosystem was different. So my dear friends, I always say that law are being made, law are being interpreted, and according to circumstances also many a times. And probably A.K. Gopalan and Maneka Gandhi, if you read together, then you see that how ecosystem or the the environment, how it affects the interpretation of law, the Maneka Gandhi is, I think, the ideal example. So let's see what Fazl Ali Justice said. He's argued that fundamental rights are not self-contained. That means Article 19 and 21 are interconnected. He said that right to personal liberty, Article 21, include freedom of movement. Without providing freedom of movement, how can you say that right to life is enough? It is not an animal life. It is life with dignity. So the dignity word came later, and Fazl Ali in 1950 itself observed that they are interconnected. However, majority decision took the other way round. That is why his observation were in minority. Then the second observation, he said that due process are inherent since procedure established by law means reasonable, fair and just. These are the three things which I always say that if you want to know what is law, so always remember JRF, just, reasonable and fair. Actually this observation was by Justice Fazl Ali, which has been again reiterated in Maneka Gandhi case as well. So he finally observed, if the law takes away liberty by a procedure which is arbitrary and unreasonable, it is not procedure established by law. So you cannot be arbitrary. You cannot be means bias. So the transparency, the fairness is the essence of the procedural law, and that is what he observed. The impact was that later interlinkage of Article 21, 14 and 19, that golden triangle what we say, has been established by Fazl Ali in 1950 itself, which was in black and white, was finally settled in Maneka Gandhi. So I have given a lot of issues and challenges in Maneka Gandhi. So Maneka Gandhi was, I told that it was at the time when emergency was in operation in 1978. Maneka Gandhi versus Union of India, it is also called passport case. The fact remains that Maneka Gandhi wished to fly outside India, and for various reasons, maybe political or whatsoever, her passport was impounded by Ghaziabad Passport Office. And again, the government took that decision, the argument in the court that we have observed due means procedure established by law, as observed or as argued in A.K. Gopalan. This time Supreme Court say nothing doing. We will not stop ourselves only for examining the procedure. We will see the substance also, whether you have been arbitrary, whether you have been transparent, or what way you have observed the procedure. That becomes very important. So the legal issues were whether procedure means any procedure, whether they are fair, transparent or reasonable or not. So they say that any procedure, no, procedure should be well within the limits of fairness, just and reasonable. Then the second legal question was, are fundamental rights interlinked or interdependent? So Supreme Court held, first of all, they overruled the ratio in A.K. Gopalan, and by and large they observed the decent order in A.K. Gopalan, and finally they observed that procedure under Article 21 must be fair, just and reasonable. And secondly, they said that due process of law in substance through means, in other words, if I say that after Maneka Gandhi, although we have not amended our Article 21, in letter and spirit it is written procedure established by law, but in actual sense, in true sense, we are observing due process of law. That means we are reviewing, or our constitutional courts are reviewing both substance as well as procedure. And if you see Mithu case, Mithu is a very, very glaring case Mithu versus State of Punjab. And there, section 303 of IPC was repealed. And series of enactments, various sections were repealed by Supreme Court by observing due process of law. Otherwise, if due process of law was not there, then they do not have the power to repeal the sections or a particular portion of any section or piece of law. And again, in Maneka Gandhi, it was observed that Article 14, 19 and 21, they are interlinked and it is called golden triangle. So what Fazal Ali Justice said, it was actually concretized, it was vehemently mentioned in Maneka Gandhi case. So in my opinion, Maneka Gandhi is a watershed case where the journey started from A.K. Gopalan through R.C. Cooper, or before that in 1967 Golaknath, then R.C. Cooper in 1970, then Kesav Bharti in 1973, and of course there is a blot which is called Shukla versus State of Madhya Pradesh, and then the final judgment is Maneka Gandhi versus Union of India in 1978. So this is a very, very important journey. The student of law must make a list and must understand what is written over there. So I have just given a kind of comparative matrix in A.K. Gopalan and Maneka Gandhi. This slide will give you the gist how that they differentiate. Key doctrine. In A.K. Gopalan, it was very narrow and literal interpretation of Article 21. However, Maneka Gandhi case, it was means expansion and very purposive interpretation. Then the linkages in rights. In A.K. Gopalan, the majority decision was that different fundamental rights, particularly 19 and 21, they are not interlinked, they act in silo. However, in Maneka Gandhi, it was told that procedure must be fair, just and reasonable, and there is a golden triangle of Article 21, right to life, 14, right to equality, and then right to freedom, Article 19. Then judicial review, the rights are in silos, however, the rights are interlinked, I said. Then outcome limited to formal legality, conservative approach was observed by the majority decision in A.K. Gopalan. However, in Maneka Gandhi, it was very progressive judgment and it expanded the wings of judicial review and it introduced fairness, just and reasonable component in judicial review. Now, you just see the list of different judgments, although we will expand these judgments in the next slide, but I just, in the beginning itself, I have given a matrix so that you can understand. In USA, who can review? All courts. They can review, like the federal court, federal Supreme Court, the state Supreme Court, state high courts also. And you will surprise that many of the states have their own constitution, right? So, in Supreme Court, there are certain features, in United States, there are certain features that Supreme Court, each state has Supreme Court, each state has their own constitution. However, there are federal Supreme Court, which is single in the country, and there is federal constitution, which is again single for all the country, all the states, and federal Supreme Court looks into the constitutional matter of federal constitution. Then in US, all courts, and they are concrete. Concrete means concrete and a priori, the another way, or post priori. So the type is concrete, that means that once the enactment is there, then only judicial power is there. And landmark judgment is Marbury versus Madison. We have discussed it at length. You remember in 1803 when Marbury was he was appointed a Supreme Court judge by the previous government before they stepped down, and the new president to be sworn in the next day. And the Secretary of the State, Madison, refused to issue the commission. That means the appointment letter. The Supreme Court of United States said that commission has to be issued. It is not your sweet will. Because President, when he was in power, he has given the operation. So rule of law says that that order is valid and he should be permitted. There may be some political reason, but on the face of the law, you cannot take them into account. In India, Supreme Court and High Court, as I told, that these are called constitutional court, and they have the power. We again have concrete type of judicial review. Concrete means that once the law has been enacted, then only judicial review power with the Supreme Court. And very important judgment is Kesavanand Bharati versus State of Kerala of 1973. Then United Kingdom, all courts have the power for judicial review. They are mainly administrative, and Miller case of 2017 is a very glaring case regarding EU issues. We will talk this case further. Then France, they have the Constitutional Council. Constitutional Council actually looked into the various proposal of constitutional amendment or anything. So there is a body called Constitutional Council which review before the law is being made. So it is a priori and it is called abstract. And the landmark judgment is freedom of association. It is a political party was disbanded. We will talk about this case. Then Germany, it is Federal Constitutional Court only can review. It is abstract and concrete like in France. And Luth case is very important case. Then in South Africa, these are the Constitutional Court. It is again concrete. That means only after the law or amendment is in place, then only judicial review is possible. The important case is Mac, Swaine, and we will be discussing these cases in detail. If we see little more about how these cases have contributed in the evolution of judicial review process. So in United States, as I told, Marbury in 1803, it introduced judicial review. This is probably the first case. So all of you, those who are willing to write any competitive exam or maybe graduation or post-graduation exam of law or otherwise for various other discussions, this case is a very, very landmark judgment in various respects and particularly for constitutionalism or judicial review and various dimensions of constitution per se. Brown versus Board of Education, it actually talk equal but different. The problem in this case was that the black children, they were being kept in the separate school. So they said that they are equal but different. So this clause was actually found unconstitutional in this case in 1954 in Brown case. Very significant. Then in India, A.K. Gopalan versus State of Madras, we have already discussed about this case. Kesavanand Bharati is very prominent, and I think this is the most important contribution of Indian judiciary to judicial review for global jurisprudence. So basic structure doctrine is innovation of Indian judiciary in 1973. Maneka Gandhi case is also very important, where we have shifted from procedure established by law to due process of law as far as judicial review is concerned. In United Kingdom, Miller versus Secretary of State in 2017. This is Miller first case. Another case is Miller 2 case, that is in 2019. But here, for our purpose today, Miller first case is important, where Parliament must authorize fundamental constitutional change, rule of law. Here again we will take up what was the detail of this Miller case, very interesting, and we will see in the discussion. In Germany, Luth case, the basic right binds all laws, and this was the outcome. In France, freedom of association, preamble rights enforceable, modern constitutional review. South Africa, the McWine case of 1995, it is related to death penalty, which was struck down by the Constitutional Court, and it was a bold human right review. Now let's see United States. As I mentioned, this very prominent case, Brown versus Board of Education in 1954. This is very significant judgment in the history of United States. The facts was challenge the racial segregation in public school. We said separate but equal. Right? This clause, this doctrine was established in Plessy versus Ferguson in 1886. Just imagine 1886. Equal but different. African American children, they were denied admission to all white schools. So they were saying that they are equal but different. So that is why they were not being permitted in those schools where children of the whites were studying. So this was the discrimination, and the legal issue was that such type of segregation of public school violate the equal protection clause of 14th Amendment of United States Constitution. United States Federal Supreme Court held that unanimously they decide, and the judgment was pronounced by Chief Justice Earl Warren. He said that separate but equal is inherently unequal, and that is why it abrogated that and said that the ratio in Plessy versus Ferguson was unconstitutional, and thus it is a landmark judgment to advance civil rights and equality. So in true sense, because if you segregate the children in their school level, they have that different mindset and they feel segregated in the society. And I think if you see in United States and many other developed countries and other countries as well, that in particular school, all children, irrespective of their social status, but in that territorial area, every children goes to the same school. And I think for developing egalitarian society, this notion is very, very important and well taken. Then United Kingdom, as I said, that the petitioner was Miller versus Secretary of State for European Union in 2017. This is called Miller first case. He also filed another suit, was decided in 2019, and that is called Miller 2 case. So in Miller first case, the facts were Brexit. United Kingdom government claimed to exit from European Union under Article 50 of TEU using prerogative power alone. Gina Miller, he was the petitioner, argued that only Parliament can authorize such exit. Basically, without taking approval by the Parliament, the government decided to exit. And Miller argued in his petition that Parliament approval before taking exit under Article 50 was mandatory. You must be knowing, as we have discussed earlier, that in United Kingdom, my dear friends, Parliament is supreme because they do not have any written constitution. So Parliament is supreme. And here it was challenged because government took suo motu decision to exit from EU without taking prior permission from or prior approval from their Parliament. So the legal issue was, could the executive use royal prerogative to fundamentally alter domestic laws and rights without Parliament approval? So whether without taking Parliament approval, can they change the laws, one can say. The ruling was, Supreme Court held that government must get Parliament approval before any kind of amendment or any kind of making the law or withdrawal from European Union. So that was the supremacy of Parliament was established by this judicial review power of the Supreme Court of United Kingdom. Again, I repeat one important point which we discussed last time. In 2009, the Hall of Lords were converted into Supreme Court. So Supreme Court per se came into existence in 2009. Earlier it was Hall of Lords. Then in South Africa, State versus McWine, 1995. If you remember, the fact of this case were death penalty legality was challenged regarding the interim constitution of South Africa of 1993. Basically, they brought interim constitution in 1993. However, their final constitution was enacted in 1996. So this was the case of 1995. Issue was, does the death penalty violate the right to life and dignity? Ruling or the Supreme Court held that death penalty is unconstitutional, and it was held that South Africa new constitution must break from the past of apartheid. The significance of this case is that it laid down the foundation for protection of constitutional right in the Constitution 1996. So this was a very prominent case prior to the final version of South African Constitution in 1996. In Germany, very important case of 1958 named Luth case. The fact was Luth was a journalist. He called for a boycott of films directed by Wet Harlan, who was a Nazi propagandist. Harlan sued Luth for violation of economic freedom. He said that because he has declared the boycott of his movies, so it has violated his freedom of earning, or you can say freedom of economy. The issue was whether constitutional right, freedom of speech bind private law dispute between citizens. The ruling was the Federal Constitutional Court held that basic rights have indirect third-party effect, and they radiate into private law and guide interpretation of civil law. Basically, judicial review applies beyond direct state action, save all laws. I think this is the most important case in my views, my dear friends. It has impact of 1973 case in India, case Vanand Bharti. The basic structure, to my understanding, that was emanated with the experience of Germany and particularly this Luth case. Then France, freedom of association case, very famous case of 1971, where the then government actually banned, or the French government, parliament of that time amended a law to dissolve association more easily, and the issue was whether new law was consistent with the freedom of association guaranteed in the preamble of the Constitution of 1946. Actually, the preamble of our Constitution was also borrowed from France. The ruling was the French Constitutional Council struck down the law, recognizing the preamble's right and principle as having constitutional force. So it established modern constitutional review in France. This is the, you can say, the landmark judgment for introducing judicial review per se, and it opened door for abstract judicial review of legislation before comes into power, because it is called abstract type of judicial review. Now the last slide, my dear friends, the constitutional remark. Judicial review ensure constitutional supremacy, that is rule of law. As I said, that judicial review is the core to maintain constitutionalism, and thereby you can ensure rule of law, equal protection of law, equality before law. So judicial review is a very, very sacrosanct power, and I think because of this power, the Supreme Court or the Supreme Judiciary can claim to be the custodian of the supreme law, that is constitution. Then check and balance of power. As I said, that there are the three organs of the government. One is judiciary, the legislature and executive. So judicial review actually balance. Although there are some aberration, there may be some judicial overreach. However, judicial review remains very, very important part in the democratic setup. Then innovations, the basic structure doctrine in India, case 1 and Bharti case, we have already discussed. Then it evolving process, always it is evolving, and from a narrow procedural check to a broad substantive safeguard, something like A.K. Gopalan to Maneka Gandhi, which we have discussed. So it is an evolving process, and in many other countries as well. It has wide scope. It has test for constitutionality, reasonableness, abuse of power, protection of constitutional itself. Challenges, there are judicial activism and judicial overreach. Now in the age of artificial intelligence, there are so many challenges for the judicial review. Then data privacy, protection of data and all. It is eternal vigilance is the price of liberty, and the judicial review embodies this idea in every constitutional democracy. So with this, my dear friends, I always appreciate your patience, your commitment to the cause of learning, and it is better that we should have more and more planning in future. You suggest us, you give your ideas, you give your comments in the chat box, and we shall abide with your suggestions, with your arguments, and be with us. Subscribe the channel, advise us as and when you require. Feel free to interact with us. Thank you very much. Namaskar. Jai Hind. Jai Bharat.